Welcome to Police Roll Call. I am Stanley Cohen, a former police officer with the Cincinnati, Ohio Police Department and a former professor of law at Indiana University, Pennsylvania. The goal of this channel is to state court decisions which explain the law to assist police officers to enforce the law on the street and to enable them to defeat motions by defense attorneys to suppress evidence and motions by defense attorneys to dismiss charges. Now, today, I am going to state an important court decision and an explanation of how this court decision can help police officers in all of the states of the country. The case is Montoute versus Carr. This was decided by the United States Court of Appeals for the 11th Circuit, and the court ruled in favor of a police officer. The facts are as follows. Officers arrived at a bar in Sebring, Florida, and they heard a gun being fired. They saw a man walking toward them carrying a sawed-off shotgun pistol grip. The officers repeatedly told him to drop the firearm, and he refused to do so, and he walked or ran past the officers. The officer Carr chased the man down a street. The man never turned around, and he did not point the gun at the officer. But the officer still fired one round, hitting him in the buttock, and the man sued the officer, the city of Sebring, and the chief of police. The trial court denied the officer's request for qualified immunity, which, if granted, would have required the complaint against the officer to be dismissed. So Sergeant Carr appealed. Now here's the explanation for all police officers in all states of the country. Police officers may cite this case in any court that their case is being tried in if the ruling by the court will show the legality of the force that you used in your case, and if the facts in your case are sufficiently similar to the facts in the Carr case. The 11th Circuit Court of Appeals, which decided the Carr case, has binding jurisdiction on the courts in Alabama, Florida, and Georgia. However, the police officers in states outside of this jurisdiction may still cite the ruling of this court to show the legality of the force you use if the facts in your case are sufficiently similar to the facts in Carr. The reason is this. When a ruling in a case does not have binding jurisdiction in a court decision because it is in a state not within the original jurisdiction, the court may, if it considers the ruling reasonable and sound, give the ruling what's called persuasive jurisdiction over the court, which means that the court may allow the decision to be binding law in its court. And when the ruling is applied to the facts in your case, the court may conclude that the use of the force used in your case was lawful under the reasoning in the Carr case. Police officers should remember this about all federal court decisions I brief and post on this webpage. Thank you for watching this video, and please subscribe below to watch more court decisions.